Welcome once again to Lehto's Law. Here's Steve Lehto.
Scott sent me the story out of Florida. I said, Steve, check this out. Woman says she lost her land rights after signing blank paper. Blank paper. And this is an interesting question. And so we'll get there. Walt Butel wrote this for WFLA. A Florida woman is struggling to regain her rights to inherited land that she claims she lost by signing a blank piece of paper. You might ask, why'd she do that? Well, that's one problem. The question next is, wait, how does a blank piece of paper turn into you losing your property rights? The dispute involves a 3.5-acre piece of land with a small home on it on Martin Road in Hillsborough County. It was inherited by the children of the previous owner, and according to a number of online sites, might be worth $250,000. But earlier this year, the ownership changed, at least according to the paperwork filed with the county. Now, this woman, who's 80 years old, claims that her next-door neighbor approached her with what she said was a high-pressure sales tactic and a blank piece of paper. Now, a high-pressure sales tactic sounds like he's trying to sell her something, and it's unclear if that's the proper phrase that she should be using there, but a blank piece of paper is what you think it is, and that's a blank piece of paper. We were at a birthday dinner, and he was very aggressive. He continues to say, just sign the paper. And I'm saying, I'm not signing anything. I don't even know you. Now, it was a next-door neighbor, and she eventually gave in. She said, I did sign it. It was a blank piece of paper. So she claims that her signature on the blank piece of paper somehow ended up becoming a quitclaim deed that effectively removed her name from the deed and eliminated her stake in the real estate. And a quitclaim deed is this idea that if I own something that is real estate, let's talk property here, real estate. I own a piece of property, and there's a deed somewhere filed that says I own that piece of property. There's a bunch of different ways I can transfer the property to you, and one of them is simply I can give you a quitclaim. And a quitclaim says that I am, in essence, giving up my claim to the property. Quit claim. That's literally what that means, okay? So back when we used to name things, when they made sense. So according to the county sheriff's office investigators, surveillance video shows the man filing the paperwork that put his name on the deed, and the woman says she tried to stop it, but it was too late. And that's when she realized what happened. And she said, I'm in trouble. I think I've done something stupid. In June, the sheriff's office turned its investigation over to the county state attorney's office, according to documents reviewed by 8 on Your Side from WFLA. And I'm guessing the state attorney's office has offices in different counties. Therefore, it'd be the county state attorney's office. I'm guessing. It's a bunch of adjectives there. The state attorney communications director, Aaron Maloney, said the case is still active, but no charges have been filed as of today. Meanwhile, the neighbor referred the TV station to his attorneys who are defending him in a lawsuit filed by the woman. And so she's filed a lawsuit against them. And the attorney says, my client has not been charged with a crime, and he's not been found guilty of a crime. And of course, the question is, was that what he was asked? In the neighbor's response to the woman's civil lawsuit, he denied doing anything wrong and stated, the deed is not fraudulent and was not signed under fraudulent terms. The question, of course, is, was it a deed when she signed it? He also claims that the woman's sister was compensated $40,000. Groceries, healthcare payments, and an air conditioning unit were all tossed into the deal. So $40,000, an AC unit, groceries, and healthcare payments paid to the sister. Now, it turns out the sister lives in the home on the property. She's also named in the civil lawsuit, but she's not responded to any request for comment from the TV station. Meanwhile, the woman here says that she has not received any money from the man who now appears to be on the title to the property. None, she said. This has been awful. I've wanted to say just forget it, to heck with it. I didn't know people could just go in and take your property. Well, they can't, generally speaking, unless you sign it over to them. The question is, why'd you sign a blank piece of paper? Now, the children of 2 siblings of the woman and the person on the property have passed away, but their heirs remain on the deed according to land records. So it still appears that there are people who do appear as owners of the property, but the guy who got the quitclaim deed apparently has done something to indicate that he's also an owner. Because remember, more than one person can own a piece of property. So here's the question. You sign a blank piece of paper. I, as your attorney, would advise you not to do that. But the question, of course, happens, people don't call me because they've done nothing wrong. They usually call me after they've screwed up. Bad things have happened, that's why you call an attorney. So you call an attorney and say, hey, look, I just signed a blank piece of paper, and I think bad things might happen. And I go, oh, why'd you sign it? Now, that doesn't help us any unless you say, oh, the person told me, like, hey, I want your autograph. I once met Billy Sims. The older guys in the audience know who I'm talking about. Long before Barry Sanders, Billy Sims. And Billy Sims came into the gas station I worked at, and I got his autograph. He signed a blank piece of paper. I handed him a piece of paper and said, hey, Billy, can I have your autograph? Pleasure to meet you. I probably called him Mr. Sims. And he very, very nicely, thank you very much. And signed the autograph for me. So he signed a blank piece of paper. So it's not unheard of that people sign a blank piece of paper. But of course, if someone walks up to you at a birthday party and hands you a blank piece of paper and says, here, sign down here in the bottom right-hand corner. It's not an autograph, right? And so the question then becomes, what would be your liability for signing a blank piece of paper? And generally speaking, there isn't any. No, you're not agreeing to anything. Keep in mind that written contracts are evidence of an agreement. But the piece of paper itself is not actually the contract. And I have people say, but Steve, that's the contract. No, it's not. And you know how we know that? If you and I have an agreement, and let's say I agree to sell you my car. And you go, I want to make sure this is ironclad. Let's write up a contract. So we write up a contract. I sign it, you sign it. You hand me the money, I hand you the keys, I hand you a signed title. As you're walking down the driveway to get in my car, I change my mind. I tear up the contract. Does that void the contract? What if you tore the contract up? Does whoever has access to the contract have the right to tear it up and cancel the contract? And I'm talking about just, let's suppose there's only one copy of the contract. The contract is the agreement between the parties. And the contract, the written one, is evidence of that agreement. There have been countless, innumerable contracts enforced by courts where the original contract is long gone. And so let's suppose the parties come into court and they go, we both agree there's a contract. Judge says, show it to me. We don't have a copy of it anymore. I guess you guys are out of luck. Leave. No. The contract is the agreement. It's a legally binding agreement. The fact that it's written down on a piece of paper labeled contract doesn't make that the contract. That is simply showing you what the contract says. So if I sign a blank piece of paper, I've not agreed to anything. I've signed a blank piece of paper. When you write above that something that I didn't know you were going to write, I'm not legally bound by it. So then you say, but Steve, what's this woman's problem here? Well, she's saying that the piece of paper was made up after she signed it in a way that made it look like she was giving away her property, but she didn't know that because the language wasn't there. This guy presumably could go, I handed her a quitclaim contract and she signed it. So now it becomes a proof issue. And so this is one of the things that a lot of people argue with me about. They go, Steve, if I did this, I could go into court and explain it. Yeah, you could. And the other side's going to go into court and explain it the exact opposite way. It's your word against theirs. Just because you're right doesn't mean you'll win. A court, a jury, a judge, someone's got to believe you over the other side. So when this woman goes into court and says, I signed a blank piece of paper, the other guy could come into court and go, no, I got a piece of paper signed by her. It's notarized. Oh, let's call the notary and announce what the notary says. I mean, I don't know. That's a possibility. Also, were there witnesses? Did anybody watch them sign the piece of paper? So I can speculate here, which I hate to do because people say, but you don't know any. I'm simply pointing out that if I was a judge and someone came before me and said, Steve, Your Honor, this is a quitclaim deed signed by her. I look at her and go, did you sign that? She goes, well, I did, but it wasn't filled out. What wasn't filled out? It was a blank piece of paper when I signed it. Really? How often do you sign blank pieces of paper? Why would you do that? He badgered me into it. Okay. Sir, what do you say to that? No. I talked to her about acquiring the property, told her I was going to help her sister out and blah, 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 blah. And I had the quit claim, put it in front of her, she signed it. Now what? Well, are there any witnesses? Was anybody else there? This happened at a birthday party at a restaurant. There probably were other people there. But did any of them see what was happening? And so it gets down to an issue of you're trying to dig yourself out of a hole, but in a situation where all the facts come to light and are understood by the judge, simply signing a blank piece of paper would not have any legal effect if you could prove that's what happened. The problem is it is so difficult to prove that that's what happened. So I shook my head when I saw this because I thought to myself two things. One, she shouldn't have done that. But two, technically speaking, the signing of the piece of paper doesn't do anything. However, it does allow a bad actor to put language above your signature and then make bad things happen. If that's what happened. And we don't know. We don't know. So there you go. We'll find out later on, I suppose, if anything happens here. Scott, thanks for sending from WFLA out of Hillsborough County. Woman says she lost her land rights after signing a blank sheet of paper. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I'm playing all the right notes, but not necessarily in the right order.